Your Worship, last time this matter came before you in the 27th of February, we had made a bail application, and we thought to leave of court, which was granted to present sureties for 820 that we are not in court that day. And Your Worship, with your guidance, we can proceed.
Proceed. I believe it's better that state answers to an omnibus.
Yes.
You're objecting?
You know, certainly.
No, let him first present
Most
them.
obliged.
At least we have them on court record.
Yes, Your Honor, we uploaded these documents on ECMIS.
This is 820?
Yes, for 820 on the 27th of February when we last appeared. The only issue that we had that day,
On
27th of February, the only issue we had that day is that these sureties were locked outside the court premises, as we notified them. And in the area of ECMIS system, the prosecution ought to have seen this judgment since it's them that actually initiated this case.
The problem with me recording in that manner is that you're arguing with something that has
No.
not been put on.
Okay, Worship. So we can first present the sureties, then we
Okay.
address that one.
Yes.
I will call Amina Nabagwa.
Amina Nambagwa.
Tinambagwa.
Nambagwa.
Tinambagwa.
What should I keep?
Yeah. Tivanagwa. Amina.
Okay. On judgment and ruling?
Amina, you
Below the
come
one
this
for
way.
bail application?
Yes, Vanagwa Amina. She's aged 63 years. 63 years of age. Is a resident Tivanagwa Amina. Resident of Ontoloko Central. Kanyansi Ward, in the local district. She's a farmer by occupation. Her relationship with the accused is that she's a biological mother.
Those who are talking in my courtroom, I'm going to request that you step out.
The second one is Farouk. That's right. Mujeni Krovis.
Mujani Lovis.
Mujeni Krovis. Is he around? Maybe the other can help us to raise.
N9.
N9, Sauda Madada?
This question was among past ten accused persons who had previously made their application for bail before this honorable court. Your Honor, this honorable court, in its discretion, dismissed all the 10 bail applications, including A9's application. And the reasons for the same are given. Your Honor, to save court's time, I will not revisit the said decision of the court. Your Honor, the applicant number 9 in her application that was eventually dismissed, among the reasons she gave was that she was sick. Your Honor, which same reason has been advanced during this application? Your Honor, the position of the law on subsequent bail applications has been made clear. In High Court decisions, including case of P.O. Simon Peter and another versus Uganda.
Yeah.
P.O. Simon Peter and another versus Uganda. High Court Criminal Miscellaneous Application number 74 of 2023. In another case, Molly Katanga versus Uganda. High Court Miscellaneous Application number 93 of 2024.
Miscellaneous application?
Number 93 of 2024. Your Honor, a copy for the court. My learned brothers tech savvy. They can access it on the internet. Your Honor, in that said,
So it should be the
decision,
opposite because the other one is going to do a rejoinder.
That's the bride.
Your Honor, in that decision of the court, Honorable Justice Isaac Muata had this say, and I quote, from the onset, I note that an accused person has a right to make successive bail applications as many times as possible. However, the subsequent bail applications, the same court shall lie only on a fresh ground or new fact which did not exist at the time the first application was made, or where there has been a material change in the circumstances that led to the rejection of the first application. Your Honor, we invite the court to find that applicant number 9 has not moved court in her application or otherwise, that their circumstances that are different in the material as compared to the time she made her first bail application. Your Honor, the applicant presented 2 sureties,
According to that is what? Eh?
A9,
Still a 9.
still A9. The applicant, I beg your pardon, presented 3 sureties, including Mr. Balaga de Simpo, the father, Miss Namiro Deborah, mother, and Miss Nansubuga Damalie. A relative, an auntie, Your Honor. The applicant also stated that she was a breadwinner for her family. Your Honor, the applicant did not in her application expound or explain what she meant by being the breadwinner for her family.
I didn't know that.
The applicant never explained to this honorable court what he meant by being the breadwinner for her family. Considering, Your Honor, that the letters presented by the 2 sureties, the parents, these are residents of Njevu Municipal Council, but according to the charge sheet, Your Honor, he is a resident of Mulenga, Nwakiso district.
The applicant?
The applicant, according to the charge sheet, the resident of Mulenga, which is in Nwakiso district. Your Honor, the sureties presented were said to be farmers. And therefore the application was left hanging when the applicant did not explain that she was the sole breadwinner of her family.
I think I'm getting you right straight. My minutes seem to be confusing. I don't know if I'm confused alone. You're referring to who in particular? The sureties or the applicant?
Your Honor, the applicant,
Mhm.
who is a resident of Mulenga,
Mhm.
sureties being residents of
Injero.
Njeru in
Mhm.
Jinja
Then the applicant is the resident of Bulenga.
of Mulenga.
Mhm.
Your Honor, even if the prosecution wanted to imagine that the parents were dependent on her, it is not.
You're not giving them the conclusion that we are expecting. So you
Your Honor,
don't leave
that's
it
why I'm
hanging.
telling you, Your Honor.
Okay. Then you say the sureties were said to be farmers.
Yes, Your Honor.
Okay.
Your Honor, the applicant did not satisfy the court. On what she meant, by what she meant that she was a breadwinner for her family, because in any case, the parents would not qualify as vulnerable persons as defined by the Constitution Bail guidelines. Your Honor, we pray that you be pleased to dismiss A9's application.
Your Honor, before still proceeds, who's the person who wants to confession? Some of them, as we proceed with the main.
How many?
And there are two. How many? There are three. Four.
Don't foresee it. Hmm? Don't foresee it. Hmm? Prisons, can they be helped? Let them be helped. We are praying that the court is pleased to dismiss N9's application.
Yes, Your Honor. This being successive third attempt, first being the application for bail, second being the application for release on mandatory bail, and now being the third, Your Honor, however, without giving circumstances that are different from the ones that were previously given to this honorable court. Your Honor, for applicants 1 to 10, as the prosecution is our humble submission that there is no such a thing as adopting proceedings from previously. Your Honor, this was the submission that the court be inclined to adopt. Your Honor, an application ought to be independent And therefore, it is our humble submission that A1, A2, 3, 4, 5, 6, 7, 8, and 10 are not part of the applications for which we are prepared to respond today. Your Honor, however, the court be inclined to take them on their application for the court to consider the previous two applications that were dismissed, where the court to first invoke its powers or discretion grant or not to dismiss this application, but also to refer to the earlier High Court decisions that I've just mentioned, Opio Simon Peter and Ole Katanga versus Uganda, on which successive applications for bail ought to be substantiated. There too, the court will consider gravity of the offences for which the accused persons are charged, Your Honor, particularly unlawful drilling which whose maximum sentence is 7 years Your Honor, we invite this honorable court also to consider the antecedents of the applicants but also, Your Honor, possibility of a substantial delay the trial, the likelihood of the applicants interfering with witnesses, and whether there are any other charges pending against the applicants. Your Honor, applicant number 11 has a known criminal record.
11 years. The name?
Olivia.
Olivia.
For which I will invite this honorable court to take judicial notice that she, in fact, was pardoned. Your Honor, the same Your Honor, on the aspect of whether there is a possibility of substantial delay of the trial, we submit that the state has disclosed evidence and therefore there is no likelihood of the delay in the prosecution of this case. Your Honor, on that aspect, the High Court the case I just cited, Katanga, disclosure of material evidence that the prosecution was to rely upon was a ground for further denying the subsequent bail application. Your Honor, this is at page 5, the ruling that is dated 21st May 2024. Your Honor, all the evidence, beg your pardon? It is, and therefore there is no possibility of delaying the hearing the prosecution's case. Your Honor, we also invite this Honorable Court to consider the fact that some of the applicants did not provide this Honorable Court with copy of his national identification card, the fact that he did not present a copy, or rather an introduction letter from the local council leadership of his area of residence. Your Honor, now submit generally paragraph 12, the Constitutional Guidelines provides that applications of this nature shall contain particulars of applicants accompanied by national identification cards or any other identity, Your Honor. They are listed there. They accepted. Accused number 12 did not provide any of the two. Your Honor, accused number 13 only availed this Honorable Court a copy of his letter of residence, Your Honor, in the said it is stated that the applicant is a resident of Amazon Village, but does not provide a letter of identification. Your Honor, but also his proposed second surety, Yusuf, was not in court, and therefore only one surety was presented. C. Edward, who was said to be a brother, the mechanic. Your Honor, this applicant C. Beg your pardon. This applicant presented Mugerwa Yusuf, who was not in court, but did not provide a copy of his letter.
Which applicant?
Applicant 13.
Yes.
Presented, did not present an ID, but the surety is presented. One called Mugerwa Yusuf was not in court that day, but they only presented a national identification. Your Honor, we invite the court to look at the age difference between the applicant and his surety, who is said to be 30, or rather 29, and while the applicant was 27. Your Honor, to save court's time, we will invite the court to consider the age differences of the applicants and their sureties. But again, the other surety also only presented a copy of his letter of introduction, but no identification card. Your Honor, which are requirements under the constitutional guidelines. Your Honor, A14 also presented one surety. I beg your pardon. Your Honor, the F14 presented sureties, including Nambi Jamagi, who was said to be the sister, but also this applicant did not provide copies of his letter of introduction and national identification. Your Honor, A15 presented two sureties. Including Kayimba Abubeka Namte Sarah, who were said to be 37 and 40 years respectively. Your Honor, and the relationship, Your Honor, between the applicant and Namte Bisara, that she is a friend. The applicant does not tell for how long. Your Honor, we invite the court to find that this relationship not close enough, given the stakes, the case, the gravity of the case, and the maximum sentence should they be convicted, Your Honor. Your Honor, I will go to A16. Abega Majid. Your Honor, we invite the court look at the relationship between the applicant, his sureties, and the age differences. Your Honor, for A17, invite the court consider fact that this applicant only presented a copy of his letter of introduction, but did not provide proof of his. He only provided a copy of his letter of introduction, but no identification document. Your Honor, we also invite the court. It is quite odd that charge sheet indicated that the applicant was a resident of Chanja Nakawa Division. Your Honor, this charge sheet was tendered in court. It was never challenged. However, the applicant presented his letter of introduction indicating that he is a resident of Kabowa Parish, Wankulukuku Village, Rubaga Division. Your Honor, one wonders whether he was able to shift while he was under lawful custody. Your Honor, the letter indicates he's a resident of Wankulukuku Village. A9. A11 to A21, excluding A20. This application has just been made. And be pleased, Your Honor, fix this case for hearing. So pray.
I'm not going to take on the rejoinder. Time is past spent. Yes,
Your Honor, very quickly on one or two things.
on that, are you rejoining?
Yes.
I want to run away.
Because it
Are
affects.
you all going to rejoin?
Shall be believed. No, it's not.
And I don't want to, from coming to 3, I had other matters scheduled for this day.
It
It
won't
has
be
become
all,
repetitive
and we're going
that
to
I am
make it
pushing this.
very quick, Your Honor. Your Honor, State has severally quoted the case Moli Katanga versus Uganda High Court miscellaneous application number 93 of 2024 in inviting court to dismiss the bail application. Your Honor, part of the quotation alluded to by the State in this ruling. The second, and I'll read verbatim, the second or subsequent bail applications, the same court shall lie only on a fresh ground or new fact which did not exist at the time the first application was made. Your Honor, in as far as A9 is concerned, the illness persists. Yes, we talked about illness the other time, but the illness persists. And Your Honor, we don't want it to deteriorate further. That's why we are relying on the same in seeking for bail for A9. Your Honor, again in this same ruling, the trial judge said,
Your Honor, just for clarity, I don't know if my learned brother has taken instructions for him now that
yes, we have.
the lawyer is still on the floor.
She indicated when she was still on video.
She said she had not
The other
met.
one.
The
But
other
she
one.
was okay
I
with
don't
this
know whether
one.
that meant that she was.
No, she mentioned that these ones have represented her before.
Most of that.
Yeah.
Your Honor, we request that the State follows the same way we are following, so that we are on the same page, Your Honor. Your Honor, the trial judge here said the application for bail is dismissed on the basis the circumstances for the applicant in custody have not changed and the matter is not ready for hearing. The key word here, Your Honor, is ready for hearing. Your Honor, we've been here time and again. And what's clear is that State is not ready for hearing of this matter. So he's erroneously relying on this case. Your Honor,
I don't know if the misdirection is deliberate or my learned brother was not attentive. I said the prosecution was ready to proceed.
Let him.
Your Honor, he's deliberately distorting.
Your Honor, we have been here for several weeks.
Allow counsel to air his point, and I do my job.
Most obliged, Your Honor.
Yes?
Your Honor,
Counsel, feel free to address.
have been here severally, and that's what we are talking about. The State has not been ready for hearing thus far. The State also said that the applicant did not explain to court what she meant by being breadwinner for her family. And what he alluded to was that the applicant is a resident of Mulenga. The sureties who are parents are residents of Njero. I don't know how that makes sense, because who says you cannot be a breadwinner to somebody who is not within the same area you stay? Your Honor, the applicant has got her own family, which she supports, but also supports her family, her parents, even though they stay elsewhere. So we invite court to disregard that claim by the state that for her to support her parents, they've got to be staying at the same place, Your Honor. Your Honor, state also indicated that there's no such thing as adopting proceedings previously relied upon, and that this application ought to be independent, of course. And that's why we applied afresh, Your Honor. We only requested court, Your Honor, to adopt the sureties previously presented. That was our request, this honorable court. And in the previous ruling of court found those sureties to be substantial. And that's why we requested court to rely on those same substantial sureties in this fresh bail application. Finally, from me, Your Honor, the state indicated that court should consider the gravity of the offenses which the accused persons are charged with, insinuating that because of that offense, they should not be granted bail. Your Honor, we would like to remind this honorable court and our colleague representing the state that these accused persons are innocent until they have conceded that they are guilty, or until this honorable court finds them guilty. That's Article 28(3) of our country's constitution. So we would like to implore our court not to view the accused persons the same way our colleague representing the state views them, because it seems view them as criminals, as convicts. These accused persons are innocent. They are presumed innocent until those two critical factors have happened. I'll invite my colleague to very quickly step right into the other remaining.
Your Honor, I'll be quick. I think the first one was an issue that A11 Chobe Ashira did not present his introductory letter. I don't know why the state does not list Ekmis account to find out, but I'm giving you a copy. But the same was uploaded on this. Your Honor, we start on the issue of Your Honor, we shall start with the issue of the national IDs for these accused people. Most of them that they allege were not presented in court. Your Honor, from the fact most of these accused people were abducted in their homes, and their items are still at police.
Your Honor, objection. I object to the language that is being used by defense counsel.
Okay, let me change, let me rephrase.
I pray that the same be expunged from the record. For obvious reasons, Your Honor, I don't have to go there. The police is mandated
That is upheld. That is upheld
To arrest.
because police is doing its role.
Okay.
Called an arrest
Yes, Your Honor.
according to the criminal
Okay,
code.
okay, Your Honor. Since state wants me to use that language, but these people were taken to police in whatever way, their items were
Can use
confiscated.
the word arrest.
Okay. If I'm guided, okay, they were arrested. They were
Arrested. Use the legal. The
okay,
legal
Worship,
word.
but it is not the way they did. But they were arrested, their items were taken and confiscated from them, including phones and other documentations. Up to now, they have not accessed them. In fact, when we tried to write to the police, they told us they are under investigation. So, also, Your Honor, the prosecution clearly has told this court that he has finished disclosing to us all the evidence in this trial. Previously, when we appeared here on the 27th of February 2026, even though the state had even brought a witness, and we told the court that we as a defense were also ready to proceed with the hearing. Based on a disclosure that was served to us on the 18th of November 2025 at 4:50 p.m. It is me who received the disclosure that day. However, on the 27th, the prosecution said he had more documents to disclose to us, and court gave guidance and ordered that all the intended disclosure ought to have been served to us by the 13th when we last appeared here, so we can start trying. Nothing has ever been disclosed to us. So my submission is that since the prosecution admits that he has crossed a disclosure, the same be adopted and we are ready to proceed. Also, Your Worship, A11, A11, according to the prosecution in his response, says she did not apply for bail. That is a trivial time. But it is on record that A11 did apply.
I think he also made a reply.
He later replied.
Yes,
Because
so
he
he
had,
says Olivia Utala has a known criminal record. We invite court to take judicial notice that she was pardoned.
okay, Worship, even if he says that this is a court of evidence, not a court of stories and mere allegations. Worship, I believe if prosecution was to rely on that allegation, they would have presented court evidence in that regard, which has not done. So I pray that that be found as a mere speculation. You know,
Which one
as
should be?
the one that the accused has was pardoned and stuff like that. That she was convicted and pardoned without any evidence to court. That one remains a mere allegation. Your Worship, there is no rule that I'm finishing. Then I invite. I'm finishing with this one. There's no law that provides for the age of a surety, for the surety to be substantial or not. The purpose of a surety in any trial is that a surety has responsibility over the accused person, and that such a surety should make sure that the accused person appears in court as and when is required. The sureties presented are close relatives, these people, and they have responsibility over them. We as the lawyers explain to the sureties their duties and responsibilities, and none of them, all of them have agreed to abide by the same. And the worship, they are here because they know what this is meaning. So I will pray that the sureties be found substantial, and I'm inviting my colleague proceed and conclude with our reply.
Your Worship, in 1 minute. One is about Olivia retires. Our land colleague invited the court to take a judicial notice. But Your Worship, even a judicial notice is guided. Section 55 and 56 of the Evidence Act, being in particular 56, gives out items of which court must take judicial notice. Our land brother has not brought any of the same. Therefore, I pray that argument to be expanded from court record. Secondly, Your Worship, our land brother for the prosecution has heavily claimed on fears, where he has said that actually the offense against the accused person is grave in nature. Some of them are most likely to fly out, of the country. All these are fears and speculation. No evidence has been brought, no affidavit from the investigating officer. This country, I know it is very quickly when it comes to trial intelligence. At least a personnel from intelligence would have sworn an affidavit, Your Worship. Your Worship, in the case of Panj versus Republic, it is a 1973 case, East Africa, at page 282. Your land brothers and sisters in East Africa, it is to say that if the courts are simply to act on allegations, fears, or suspicions, then the sky is the limit. And no one can ever say no occasion when bail would be granted whenever such allegations are made. Therefore, Your Worship, I continue call upon your attention not to fall a victim of our land brothers' allegations, which are inaccurate in nature on all fours. Lastly, our land brother for the prosecution premised major his argument on age difference between the applicants, or them accused persons, and their respective sureties. Your Worship, in the case of His Majesty Omusinga Mumbere Charles Wesley versus Uganda, it is a criminal miscellaneous application number 75 of 2016. The same argument was ushered in by the prosecution, because in that case, Omusinga at that time was 65 years, and one of his sureties, specifically that was Honorable Centenary Francis Robert, was at time 37 years old, making a difference of 28 years. While dismissing the inaccurate proposition by the state, I this to say that responsibility is not seen at the age difference. There are a number of factors that point at responsibility, and does not mean that the most responsible person is the oldest in this country. Therefore, I call upon your attention, Your Worship, to dismiss and expunge our land brothers' submission in as far as that aspect of age, among others, is concerned.
What I was avoiding.
Here's one.
Your Honor, I have one issue to allude to, one or two.
We're going to make them full, that's the problem.
Your Honor,
I have other people to attend soon.
I'm specifically in relation to 820, where the land statutory.
820, you cannot give a rejoinder, I guess.
Yes, Your Honor.
No, I will be the one to clarify, because what are you rejoining on?
We didn't respond.
Where he said, first of all, he made an application that he would not reply. And then during the reply, he also mentioned that he will not mention about 820. Yet we had already earlier made the application. That's why I want to specifically emphasize on this, basing on the existing laws and the regulations that guide ECMIS. Documents for 820 were uploaded on ECMIS, way back almost a month ago. May I, Your Honor? Your Honor, specifically, counsel for the state alluded to the fact that the documents presented by A20 are just been produced today and he seeks time to verify. Your Honor, we categorically state that the documents were produced, uploaded on the system on the 27th day of February 2026. You know, today is 27th day of March 2026. It is a full month when the documents are on ECMIS. Your Honor, it's a trade law that once pleadings have been uploaded on ECMIS, they are equally served on the opposite party. Your Honor, we submit that it is a ploy by a prosecution to specifically delay the trial of A20, I beg your pardon. On the premises that he needs to verify documents. Suffice also to note that the rest of other documents, Your Honor, the state has not produced to court any report that he ever certified the documents and he has a report. It will be the same thing, Your Honor, to A20. We therefore pray that the time to be given for the state to verify documents for A20 be ignored, as the wastage of court's time curtailed to delay the trial and the bail application for A20. Your Honor, another aspect is on the gravity of the offense. I'd like to add my voice to my land friend, Counsel Joel Senyongi, that in the case of Muizera versus Uganda, the cases of Muizera versus Uganda, miscellaneous application number 408 of 2024. Miscellaneous application number 408 of 2024. Justice Isaac Muata had this to say: that the gravity of the offense cannot be used to bar the grant of bail to accused persons. You know, whether the offense is murder or whatever big offense it is, its gravity cannot be used as a tool to deny the accused person's bail. And for that reason, we retaliate our earlier prayer that the accused persons be granted bail on such terms and conditions as this honorable court deems fit. We so pray.
Dates, but you had mentioned that you intend to appeal. I'll give a date for mention.
Your Honor, the application, not the whole.
That's why I have been holding upon your attention not to be a victim of my.
No, wait, can I explain? I'm going to give, because if you intend in the time period that you make the appeal, I will not have the mandate to call the file. Have you understood?
No.
I'm going to give a date that should be for the ruling. But that one is surfacing on the fact that if you are appeal, I will not be able to call it on that day. if the file has moved.
Our suggestion, Your Worship, is
And I also need to clarify that my orders shall be, in the next hearing, my orders shall be applicable. I would not expect any live recordings. They will be applicable unless an appeal is preferred. I'm seeing one person doing what is opposite now. Hmm? They're even taking my picture. Get for me that phone. Court orderly. I find them move forward to that gentleman there. Prisons. You also move forward to that gentleman behind there. Take for me that phone, and if you find my pictures, you bring it to me. My orders will apply in the next sitting of the bail ruling. They will apply unless overtaken or overruled or upheld.
Your Worship, the challenge is, according to what you are doing now, you already applied the law.
Yes, because they are enforced.
Yet you are saying they apply.
No. For now, I know why. Because it's not supposed to take my pictures. Yes. I will delete them and I hand him over it when I don't need it, if they are there. Because you can't come direct to a judicial office and take pictures. I don't look like I'm a. It's not right.
You're a public servant.
Yes, I am, and I do not deny, and that's why I'm here. Eh? What is he going to use my pictures for? Yes, Alex.
First of all, we wish to
Please let us hear. Alex is speaking.
we wish to state that we do not have anything personal in terms of your person, because in the earlier you stated that I wanted even to meet you. We recognize the role of this court. That is why we are always available, because we want justice. But we also want you to put we want court not to put itself in our shoes. For the last 7 months, we have been following the rhetoric. Many of my colleagues here sick. Today at Leo Chivumbi, please show your hand. Yes, the candidate was supposed to be, he's supposed to be on medication.
I don't know whether now.
No.
Please. Now,
I have got audience like.
let him talk about himself, not the rest.
I'm giving you a lift. No, let
him talk about himself.
Like I said, if you read my previous ruling, the one that I have just given today, I am the one to.
Most of blood.
Yes?
Most of blood, Your Honor.
So let me hear from Alex.
Just to allay his fears, for purposes of time management, and it is also a fact, I am the deputy spokesperson of National Unity Platform. He knows that. He is the head of security of the National Unity Platform. By rank and file, I am supposed to guide, and the reason we have been having a lot of decorum is because we have our in-house keeping. So
I like the fact that it is still going even if you are on that side.
Yes, of course,
I am happy that you've not abandoned the duties.
No, I've not been tasked to resign by party, so I still carry out the duties. So sometimes why I speak is because we don't want to take court's time, otherwise everybody will be having what to say. So we do housekeeping, and
you want this
I was
on record
stating
or off record?
It can be off record,
okay.
Because we wanted to allay the fears of court. We are not violent people. We respect your chair, but we also want court to understand that we are badly in desire of justice. The reason why we have a big legal team is because we know you are innocent, and with time we prove so. So we withdraw our earlier anger. We don't want to be misconstrued as violent people, but desperate times call for desperate.
And that's the reason I moved out so that people can cool down and we come back. And I think we came back fresher.
we look forward.
Yes, and the anger gone.
We look forward to have justice from you. And lastly, happy Easter. Because we want to we thank you.
Your Honor, in 30 seconds, I just wanted you to guide us properly.
Yes.
Because you indicated that.
No, I'm going to give a date for ruling. Yes, I'll give a date for ruling. But remember,
Kindly
this
guide me
file
on
cannot
this.
be called in 2 places at a go.
Kindly guide me on this, because
Yes.
whenever we do choose to appeal, because for example, you can call us tomorrow and say you're going to give us the ruling in the bail application.
Yes.
We shall be here. That doesn't get affected, in my view, subject to your guidance,
Okay, now
by our choosing to appeal.
because
Especially
for
when the
us,
adjournment is a short one.
Yes.
okay, for us now, let me give it literally. This is a file. I carry the whole file
Yes.
to her. If there's an appeal, I do not take parts of the file to her.
So we're asking for short adjournment.
And that's why I'm saying, so that's
For the
why
ruling.
you see I'm giving the reason I'm giving. So I do not, if you say you're going to appeal to the High Court or the Chief Magistrate, I move the file. So I do not have it at the moment when
We have
Yes, yes.
You want to avoid moving or proceeding in speculation. Let us deal with the status quo.
okay, now I'm giving the date for the ruling on the 10th of April. And so as counsel, I mean Alex, I said happy Easter. He did happy Easter.
Your Honor, before context leave,
Yeah.
there was an issue last time. When you were here, you had directed court, you had given, you had issued orders to the state attorney that today, the next hearing date, there will be witnesses in this matter.
Okay, I think that was affected by mine not appearing in the other one as well.
Yes.
So what transpired? Did they bring witnesses?
No. And that day, Your Honor,
No,
we are not wasting time. It was an order of court.
But I think
Your Honor,
let us start the hearing. Bring for us a witness on the 10th.
Yeah.
Yes. The ruling doesn't affect the witness.
What time are we?
We are starting at 10.
Most obliged.